Greetings and welcome to the What U.S. Companies Regularly Need to Know About the EU General Data Protection Regulation, GDPR. At this time, all participants are in a listen-only mode. If anyone should require operator assistance during the conference, please press *0 on your telephone keypad. I would now like to turn the conference over to your host today, Mr. Michael Bahar. Thank you, sir. You may begin.
Thank you, and thank you all for coming. We have a great turnout today with a couple of hundred folks registered from across many different industries, from banking, insurance, insurtech, multinational conglomerates, automotive companies. So this is very exciting, and I think this will certainly be informative, enlightening, and even a bit scary. It is Halloween after all, so why not? We are the firm of Eversheds Sutherland, and we have a firm of over 2,300 lawyers around the world, located in about 30 different countries. And we have over 100 lawyers who live and breathe privacy and cybersecurity, the leaders of which are here today, and including the undisputed master of all things GDPR, Paula Barrett, who joins us from London, and one of the true trailblazers in this field of cybersecurity and privacy, MJ Wilson-Bilik. I'm going to turn it over to Paula first in London to introduce herself a little bit further.
Thank you, Michael. Hello, everybody. As Michael said, I have the pleasure of leading what we do here in relation to GDPR, and I'm delighted to be spending some time with you today just to explore that further and help you on your journeys with GDPR.
And I'm MJ Wilson-Bilik. I'm here in D.C. with Michael. I've been a partner at Legacy Eversheds for a lot of years, and working with insurance and insurtech companies on data and privacy and cyber. So happy to be joining you today.
And so let's just kick things off with the big question: why should we care? Look, let's be honest, GDPR is a big, scary deal, and there's no use sugarcoating that at the top of this program. In fact, Apple's Chief Litigation Counsel has warned of the, quote, heavy burden GDPR places and the challenge it presents. And I think what's going to come out of this is that it is indeed a challenge. The scope and breadth is astonishing. But, as Paula indicated, there is things you can do, and the earlier the better, which we plan to discuss, sort of help chart that path. But first, let us turn to Paula and to answer the question, what is GDPR, and why is it happening to us here in the United States?
Thanks, Michael. So, whilst I think some folks might perhaps think, hey, this is a piece of EU regulation, it's something for those companies who are located in the EU to worry about. I think, as we'll explore during the rest of this session, it really has quite a lot of extraterritorial reach. Whilst we go through that, what I'd like to just explain maybe is a little bit about what is this thing, because GDPR, the acronym is being used more and more, but it's worthwhile just understanding really what is this about. It is data protection or data privacy legislation, which we've had for a long time already within Europe, so it's not a new concept in that respect. What it is, though, is a strengthening of that existing set of laws, strengthening it both in terms of enforcement, so yes, some scary fines potentially for getting it wrong, which is grabbing people's attention, but also it's strengthening it in terms of the rigor, the evidence that companies need to produce in order to actually positively demonstrate to the relevant regulators that they are complying. And it's something that goes beyond simply producing a set of policies and rolling out some training. It's things that require operational and technological change very often for businesses. But there's some basic concepts in why did we bother doing this, what was the motivation for regulators. really just a handful of things I'd flag here. Really, it was in part driven by advances in technology, and it is worth bearing in mind that things such as not just basic trading activity and selling to folks in Europe, but also some of the other activities that might be engaging in the use of AI, for example, big data analysis, the use of other advanced technologies are things that are going to have to take into consideration the application of GDPR. The other side of this is that also, as that technology advanced, so the regulators actually wanted to give people greater choice and greater rights in relation to their privacy, because some of those technologies mean that actually the amount of information that can be gathered and analyzed about individuals really is quite significant. And so there was a move towards giving back some control towards individuals in relation to that. I think the other piece I would flag here is that unlike some of the rules that we see in the US, this is not something that's sectoral. This applies, it's agnostic as to its application from a sectoral perspective. It applies across the spectrum. So it really does apply to any company that essentially falls within its jurisdictional reach, whether that's you're an industrial business, whether you're a consumer-facing business, financial services, healthcare, you are covered potentially by this regulation.
Paula, this is, there are a lot of concepts in the GDPR that are new and different for a U.S. audience, and I was wondering if you could walk us through some of what GDPR requires and explain some of these concepts like data controller, data processor. What does that all mean?
Translate the English into English for us.
There you go.
Thank you. So I'll try my best, because there are some unusual concepts for those of you not necessarily that familiar with European privacy law. Some of the terminology is similar to the current legislation, but the way it's structured is that a lot of the responsibilities fall on the shoulders of the organization that's referred to as the data controller. So that is the organization which determines the manner and purposes for which information is being collected. So a lot of the obligations in relation to compliance with the core principles, which I'll describe in a moment, fall on that particular organization. And then we have the other concept, which is that of a data processor. And these are organizations which, again, process information, but this time on behalf of a data controller. So they're doing what the controller is instructing them to do. They're not making their own mind up about what information is collected. They are following the instructions. Now, typically these would be service providers, maybe it's IT solution providers or other service providers. But it's something which there's a major change under the new rules in relation to. And so it's a great question to lead out with, MJ, because one of the big changes is that under the new GDPR is that processors get direct statutory responsibilities under the GDPR. They don't currently have that under the existing EU rules in a lot of jurisdictions. So that's quite a significant change, both for sectors like the IT industry, but also a whole suite of other service providers and sectors as well. So a lot of change. If maybe I explore briefly what some of the other key themes and concepts are briefly. We have a definition of personal data that's broader than you might be familiar with from a PII perspective. So it covers, in essence, it's any personal information that there's information that from which an individual is identified or identifiable. So it's a whole suite of things, and we'll come on to explore that in a bit more detail later. But it can also cover not just a name or a photograph, which might be more obvious perhaps, but it can include other identifiers. So, a code name, an IP address, that sort of thing can actually still be personal data. Even if you don't actually have a name, as long as you can identify that individual, or an individual from it, then it's personal data. So it's pretty broad in its application. we've got a lot of core principles to be adhered to, like which may be not good data practice really in some respects, but that the data should be accurate, kept up to date, it should be kept secure. You should be transparent about what you're doing with it, so tell people what you're doing with it. You shouldn't keep it any longer than you need to for the purposes it was collected for. And so those sorts of core principles have to be adhered to. Now, in some respects, again, if you know about current law in the EU, that's a similar set of principles. The changes are about how you go about evidencing some of that. The other piece of the jigsaw, which folks might not be familiar with, is this concept of when consent comes into play. So from a European standpoint, because the constraints around when you can get a consent and how you get it have tightened, consent is now being regarded as almost a last resort, as the basis on which you enable yourself to collect and process personal data. So we would tend to look for one of the other lawful reasons for processing. And that basically means that you'd be looking to say that it was necessary, for example, to perform a contract with the individual, that it was necessary to comply with law, that it was in your legitimate interest, it didn't prejudice the rights of the individual. So you'd be looking for one of the several prescribed lawful reasons for processing to justify why you are collecting and using that data. And then only really turning to consent, as I say, as a last resort. And one of the reasons I say that is because aside from the rigor about demonstrating that you have got a consent from that individual and what the content of that consent was, you have to remember consent can be withdrawn at any time. So it's not the strongest foundation on which to base any processing you want to do. So those are the sort of core sorts of principles, and then other things I'd touch on here, just again to give you a flavour of it. There's a rule about data minimization, so that you should, in essence, only collect what is necessary. So just because you have the technology and the capability to collect more does not mean you should. You should keep it to only what is necessary. And as I mentioned, you can't keep it any longer than is necessary for whatever purpose you identified in the first place. So that's meaning a lot of clients are struggling at the moment to deal with the wonderful topic of record retention. Yes, you may have been struggling with it for a long time for other reasons, but actually now it's forcing people to grapple with it and deal with it in a more expedited way. So all of that, that's a very, very high-level view of some of the principles involved. And then the wrapper around that is not only do you have these principles and rules to comply with, there's a concept called accountability. And you will hear about this a lot in the context of GDPR. What it really means is that you as an organization need to be able to demonstrate compliance and take responsibility for achieving compliance. You have a duty to comply now. So there's a lot of rigor around that, which we can explore later.
To American ears, this is revolutionary. I mean, this expansive definition of what is private info. We're used to PII. This is not just PII. This idea of only keep what is necessary is, again, it's a real shift in the paradigm. Consent as a last resort also. Usually we're all accustomed to just clicking yes on our iPhone or whatever it is, and that's good enough. But I think the GDPR approach is also reflective of that reality that consent can be withdrawn at any point, so you can't rely on that to the same degree that I think American companies have been relying on it. And, of course, all backed up by accountability and eventually fines, which we'll talk about. But because this is so, in a sense, foreign to our ears, how is this really going to impact us on the ground, Paula? I mean, it's all well and good, but are they going to be able to reach our companies? I think that's going to be a big question.
It is, and I have to say that the bad news is yes. So I think for a lot of organisations that's a painful truth that they're beginning to realise. This was a deliberate move from the lawmakers, because I think reflecting the way that ultimately technology in a lot of ways doesn't respect borders. So in essence, the legislation's been drafted to say effectively, yeah, we're going to extend the reach here if you are targeting and marketing in our jurisdiction. So a lot of the focus was perhaps in this regard more towards the consumers when they were thinking about drafting this, but it's not a consumer-only piece of legislation, as we'll come on to. So if I can sort of maybe go into a bit more specifics here. The way that it's structured in terms of territorial reach, there's 2 or 3 limbs. So there's the obvious wording that says, look, if you are targeting, if you're offering products and services to individuals who are located in Europe, whether or not they pay you for those products or services, the fact that you are actually offering them into the jurisdiction means that you could be caught by GDPR straight away. If you are monitoring the behaviors of individuals, again, located in the EU, then in essence, that again is something that you are likely to be caught by GDPR. And then if you are, in essence, processing, if you are using this data in the context of an operation that's based in Europe, so obviously if you've got branches, etc. in Europe, then again you're going to be caught by the establishment rules from that perspective. So that's the sort of the overt way of being caught jurisdictionally. And then I mentioned this concept of processors, and the other slightly less obvious ways where processors come in. So these are the organizations that use data, process it, store it, host it on behalf of controllers. And so where these processors are providing services to EU clients who are themselves controllers under the European rules, then those processors become caught by GDPR. So there is a whole bunch of service providers located in the States who will be caught by GDPR because their clients are. And then the third limb, in a similar way really, is where you have got intra-enterprise sharing of data. So in a similar way as an external service provider is going to be caught because they're providing hosted services, IT services to their clients in the EU. If you're a US parent company who has a centralized IT service function maybe, or a HR function or other function that is hosting or processing information for your affiliates in the EU, then you are likely to be caught by GDPR in relation to that sort of activity. There is no free pass for intragroup sharing here. It's caught as well.
On the subject of no free pass, MJ, I think we get the question a lot. If we're already complying with New York Department of Financial Services regulations or other insurance regulations or federal regulations, am I sufficiently covered that I don't have to worry about GDPR?
Not at all, Michael. And as you say, there are the U.S. law tends to be sector-based, and it really is. There are a few laws at the federal level, Greenwich-Bliley, maybe some SEC regs, Fair Credit Reporting Act. But most of the regs are state-based and are really divided by the kind of data that you're using. Is it health data? Is it data that has some kind of an ID that has a password to it? So there are 50 state breach laws that apply, all of which have very different definitions of personal information, and the GDPR is just so much broader. And I know we'll get into that a little bit more, and you already mentioned it, Paula, but it's a much broader standard, not just a definition. And then we get into the kinds of privacy notices that Paula was just mentioning. There are very few requirements in the U.S. to provide privacy notices that surrounds, maybe banking and insurance sectors. But beyond that, you need to have privacy policies that you are explaining what it is that you're doing. But again, it's limited. And the requirement to have consent is also quite limited, nothing as extensive, and with the kind of detail that you need to have for the GDPR. Much of the consent, as you were mentioning, Michael, is just click on this box, and now you've consented to our sharing of your data. With regard to materiality thresholds, and we'll get into this again more, but the materiality threshold for a violation of the GDPR, there really is none. It's a very almost strict liability, whereas in the U.S., if you look at some of the definitions about when there is a violation of a law, it's often very much a reasonableness standard coupled with a materiality standard. That's the standard you see in the New York DFS reg. It's also in the new NAIC model law on insurance security, data security, and you'll see much of it being surrounded by this umbrella of reasonableness. The notification timelines are also very different. GDPR, if there's a breach, you have 72 hours to notify the authorities, whereas in the U.S. that varies very much depending on the kind of sector or state you're in. And also the applicability of the laws in the U.S. tend to be focused on the jurisdiction where you're operating and not, or where your customers are located, and are not as broad as the reach of the GDPR. So very different, and lots of ways in which, yes, you might have there might be some sectors in the U.S. where you are complying with many of the aspects of GDPR, but for the most part, your things like your privacy notices and your breach reporting are going to have to change or be rethought in order to be able to comply.
Thematically, there's some overlap, right, and there is some core convergence. So, for example, one is senior officer responsibility and accountability, which is a very big deal, for example, for those who fall under the New York Department of Financial Services regulations. Now there's a affirmative certification and sign-off requirement from senior officers, if not the board. And I think in GDPR, in one sense, it's up to local member states how much they want to emphasize senior officer accountability. For example, in the UK, and Paula can talk about this more, of course, but for example, the Financial Conduct Authority is much more focused on senior officer accountability. But when we get to the fines and the regulatory fines under GDPR, the level of involvement of senior officers and board are going to factor into the fine. So the more active and involved the board is, obviously more likely less to have a violation, but if you do, it's less likely to be as bad. The flip side, though, is an absent board or senior management is more likely to not only cause problems, but increase your fines as well. But I think most of the regulators, certainly the regulators who are coming out now, and not necessarily the legacy regulations, but the ones that are really coming out now, are focused on the prevention. The proactive approach and having written proactive policies is the most important thing. We always use this example that the SEC, for example, fined a broker-dealer $1 million for a breach that caused no harm.
Right, exactly.
Why? Because they didn't have those proactive written policies. And I think GDPR also very much focuses on what are you doing on the front end? Have you written it down? Have you thought it through? So there is some convergence. There is some good news. But I think you need to have an individually tailored policy for GDPR. So turning back to Paula, a question we also get all the time, and hopefully the discussion so far has put this to rest, but we get things like, hey, we're not a social media company, this doesn't apply to us, right? And Paula, I get the sense that you're not going to give us good news on this one either.
Sorry, no. I wish I had $1 for every time that sort of question was asked. But unfortunately, there is a bit of a misconception for some that this, because its origins were perhaps aimed towards consumers initially, that maybe it only applies to those who have consumer-facing businesses. The reality, sadly, is no, that's not how the legislation was drafted. It's important that businesses do appreciate that even if you have no consumers at all, that this is going to apply to you. And that's because the way that personal data is described in essence, it doesn't favour any particular category of individual. It basically applies to information relating to a living individual, and therefore it's not a legal person, happily, but it is a natural person. So that natural person could be an employee, and that's why so many organisations are potentially caught by this. It can be not only your own employees and other categories of staff for that matter, but also it can be your customers, even if those customers are themselves corporates. Now, the way that happens is because those corporate customers themselves employ individuals. So, your contact for your account at another corporate is going to be an individual, that you'll have that individual's name and contact information. So hence it does have a broader application. I think the other piece that point picks up is that, yes, it can apply to business contact information, not just an individual's home address or contact numbers. It's their work email address, it's their work telephone numbers as well that come into play here. And so there's a whole bunch of different categories of ways, of course, that information gets caught. As I said, employees are most obvious, but it could be your vendors, your consultants, those contacts at other customers that you engage with on a day-to-day basis. It could even be, it's visitors to your premises. It's, those that are recorded on CCTV. We've got some clients who are recording CCTV and it gets fed, streamed live out to the US. It's those sorts of things where it can come into play. So quite a broad application altogether.
I think you've already given some good examples and sobering examples, including that CCTV. Right. So in a sense, there's an irony there, and in the sense of trying to protect things, you're actually implicating yourselves even more. Can you give a few more examples, particularly in the HR context, which is something that comes up a lot?
It does indeed. So yeah, sure. So in essence, it's a broad spectrum. So this will apply to people you employ, but also job candidates. So people are applying for positions with you, they will potentially get those rights too. It can be contractors and consultants, and all of that sort of plays through into scenarios so that if someone's applying for a job for you, then you have to think carefully about the information you're going to ask about them to give you in the first place. It will affect any background checking you're permitted to do about them. Is that lawful? In the first place, is it legitimate? Is it excessive? Is it necessary for the relevant purpose? Do you need to get consent from them? You have to tell them what you're doing in relation to that. So again, for example, you'd have to tell them what you're collecting, what information you are collecting, who you might share it with, including if that's getting shared within the business, the fact that it is getting transferred over to the States and how you're protecting that data, how long you're going to keep the information about them for. So you can do that a whole raft of things which perhaps you will not be used to doing in relation to job applicant information. And that flows through, as I say, to contractors and employees as well. So employees, for example, some of the scenarios we've given there on the slides, so expressions of opinion are caught. And we see this come up quite regularly. Individuals get the right to have access to information about them. And this can come up in the context of grievances very quickly, investigations likewise very quickly, because they have the right of access. And that means that they can request a copy of all information that the controller has about them. That doesn't just stop at the HR file or the centralized HR database. That can extend to all emails that have that individual as a subject matter too. So that's quite a large exercise to be gone through. It's not that far off a discovery exercise, in fact, in order to respond to individuals in those sorts of scenarios. The other categories you'll come across, and it's important to bear in mind, there's a category which is referred to in the GDPR as a special category personal data. In the current regime, it's called sensitive data. And as the name suggests, this is the sort of information that has a higher risk associated with its misuse. So it's things such as race, ethnic origin, health, religion, sexual orientation, and trade union membership. There's also extra protection, as you might anticipate, in relation to things such as criminal records and criminal offences that may have been committed. So those sorts of data are more highly protected. There are more limited lawful reasons for you to be able to collect that information. So, if you are going to rely on a consent, it has to be explicit. But there's a particular difficulty about collecting that information from individuals who are employees, because to give consent, for it to be valid, it has to be freely given. And there is a real concern, which is reflected in the GDPR, that employees cannot freely give their consent because they will be subject to undue pressure from their employer to give that consent in order to keep their job. So most of the time you're going to be avoiding getting a consent from an employee. You're going to be wanting to rely on one of the other lawful reasons. But for sensitive data or special category data, you've got fewer of those that you can actually choose to rely on. And it's deliberately more limited. It might be limited to, for example, because you have to collect it, because statutorily to perform a duty as an employer, you have to collect it. But outside of that, it's more difficult. So particular care in relation to that. I would flag one final point on this, which is around financial information. It might surprise you that actually financial information is not categorized as a special category of data or sensitive data under the GDPR. It falls within the general spectrum of personal data if it's relative to the individual. But not surprisingly, when it comes to things like security, clearly you're supposed to take into consideration the impact on the individual if that data was going to be misused, and therefore you are expected to have tighter security in relation to that kind of data.
Really, this puts a premium on sort of knowing yourselves and having policies in place for data classification, probably even at the generation stage when you generate something, classify it up front, so that going forward you know what to do with it and where it is and how to recall it if necessary. So data classification, in addition to data retention policies, are really important. I mean, MJ, you can talk more about that, because it's not just about HR.
No,
systems,
it's not.
Right?
What surprised me on that list was trade union membership. I was, as a U.S. person, that just doesn't seem to be a particularly sensitive class. But I know, Paula, you've mentioned that is definitely seen as a heightened data identification for individuals. And I just don't think U.S. corporations would even have that in mind at all. So, yeah, very interesting. But so, Paula, tell us, we've talked about HR. What are some of the other ways that the GDPR can come can impact companies with some of the other data that they would be concerned about?
Sure. So in essence, you've got a whole raft of ways in which personal information about individuals will get collected in ordinary day-to-day business operations. So email systems is the classic one. So yes, you'll have correspondence going within your own internal systems and within your own internal company, but of course a whole plethora of correspondence with other parties outside of the organisation. And of course within that, in essence, a lot of free text. So there's a lot of information that gets imparted by email that perhaps you would be surprised at. It's the classic one of people expressing a lot of opinions in email, which with the cold light of day perhaps they wish they hadn't expressed in an email, because as I mentioned earlier, that can be accessed potentially by that individual. But a range of things, so time recording, clocking in and out systems, that will be tracking effectively when people attended work or not. CCTV footage. It's going to be collecting information about, that could be public-facing. Increasingly, we're seeing cameras being deployed, as Michael said, in a whole bunch of security scenarios. The interesting developments are even in security, because what's classed as a category of special category data now is biometric information or genetic information. Biometrics are increasingly being used in security. So some ironies in all of that, but your ability to collect and use that is far more limited, because the impact to individuals, if that were lost, is quite significant. It's hard to replace your fingerprint. So there's those sorts of things which come into play. The payroll, finance, customer relationship systems, some significant systems collecting data. We've seen some where, if you happen to know your primary contact there's a whole bunch of things that get put on those systems beyond the pure contact information. It can be, hey, we happen to know that John is married. He has 3 children. His kids are going off to college real soon. He likes to go to golf. Maybe he likes to go and drink expensive wine. If all that sort of stuff gets unfortunately collected, then that's all personal data about that contact. So it would be subject to the regime. So it is something to bear in mind. And the increased use of tracking information, and I think, it's really interesting in the context of insurance these days that, we're seeing as black boxes get attached to vehicles a lot in order to bring down premiums. Well, they're potentially collecting information about the driver of those vehicles. So that's a lot of personal information that's being collected, which could be subject to the regime. So quite pretty broad span.
Paula, we're seeing how this is it's just so beyond what we currently think of as our privacy requirements here in the U.S. So what are some of the challenges that you think the U.S. businesses are going to be facing? We've already talked a little bit about this, but could you go into a little more about especially the inter-enterprise data sharing?
Well, indeed. So we have a lot of experience of helping clients work through these sorts of scenarios where they are economic drivers, in particular, are encouraging them to centralize their systems, gain those economies of scale, and bring costs down. And while that's fantastic from a financial perspective, it does mean that for many they're going to have to embrace the consequences from a GDPR perspective. So if that means that, for example, the parent company or indeed one of its affiliates in the US is actually hosting these, for example, there's a big push at the moment for centralized HR information systems or data warehouses. Similarly for sales and client relationship management systems. If the US parent or affiliate is hosting that or is indeed putting it in place on behalf of the wider group, then the impacts of GDPR will be felt. Because it will either be a case of then trying to make sure that the transparency requirements are met so that the individuals concerned are made aware of the fact that there will be this sharing happening with the US affiliates and on what basis that's happening. If the data is being transferred to them in the States, then that will trigger some of the transfer rules and the protections that might need to be put in place to protect the data in that circumstances, whether that's privacy shield or model clauses or one of the other mechanisms.
Right.
So it's a broad range of things that can happen, and as I said, there isn't any free pass here. Other regimes around the world, there are some exceptions for intergroup sharing. Australia and some of the Asian jurisdictions that have that concept, but I'm afraid that wasn't brought in under the GDPR, and so you almost have to treat each group company as though it was an entirely different independent third party. And every time you share data from one group company to another, you need to work out Is this happening as a controller-to-controller transfer? Is it happening to a controller-to-processor transfer? Is it lawful? What's my lawful reason for doing it? Have I given notice to people that I will be doing it? Have I put the right protection in place on that transfer? So it is something where it's a far more extensive analysis than needed when you are beginning to work through your journey on this about the flow of information within your group of companies.
And I think it's also important to note, I think a lot of people out there are starting to realize that there are going to be conflict of law issues.
Mm-hmm.
There are going to be GDPR obligations that conflict with U.S. obligations.
Especially
when
data retention,
sunshine laws, law enforcement requests. So, there may be ways to thread the needles, but it's going to be tough at times. And look, Paula, you were talking about this before, is there is no reasonableness. There's no, safe havens, no loopholes or intentional loopholes, I should say. At the same time, there is some real ability to fine, unbelievable amount.
Yeah, really.
Do you want to talk a little bit about that, since you've been on such a role of providing good news to everybody? Why not just keep going?
Why not? Okay. So so this is one of the headlines about that's why a lot of businesses are now paying greater attention. We, as I said at the outset, we've had data protection laws for a long time now within Europe, but aside from the territorial reach of it, the fines that go with this, the spread of the sanctions, not just fines, is what's grabbing the attention. So. Here, they've mimicked some of the antitrust approach to a degree. There is mandatory audit and cooperation with the relevant data protection authorities in each jurisdiction. These get referred to as the supervisory authorities in the relevant text. But the fines, let's go to that. The fines are calculated by reference to your annual global turnover. Now, this is either 20 million euros or 4% of the annual global turnover for some of the infringements that you might encounter. Now, a couple of things on this. The way that this turnover is calculated, they talk about it in the language of the GDPR as by reference to the undertaking. That's a deliberate choice of words. It goes to the definition of undertaking, which is used in the antitrust legislation, and essentially that allows them to look at the way that the business operates without having to be sidetracked by the legal form of that business. So it means they can look at it and say, we're going to look at the entire group. This isn't just about a breach, for example, by a single subsidiary that might be based in somewhere in Europe. If we think that actually this is something which ultimately this European entity is actually controlled by its parent, then we're going to look at the parent and the group, and we'll calculate our fines by reference to that. So that clearly means that there are some quite significant fines that can flow from this. The fines themselves are structured in two tiers. I mentioned the high-level fine at the 4%. There's a lower level of fine, which is at 2% or 10 million euros. That kicks in relation to security breaches, which may be a surprise to some, and also non-compliance by data processors. The 4% fines kick in primarily in relation to breaches of individuals' rights and some of the core principles like transparency, for example, and accountability. So, broad range of fines. In addition to that, it's worth bearing in mind that ultimately there isn't really a sort of minimum breach. Each time there is a breach, they in fact are required under the legislation to consider the appropriate measures that they have to apply, and those measures have to be kind of proportionate, effective, and dissuasive when they consider it. Now that may include fines, but it doesn't necessarily mean a fine in all instances. we had some guidance on that just released over the weekend, in fact, and the approach there is really that they don't necessarily want the supervisory authorities to be afraid to fine, but they don't want it to be an instant fine every time because they recognise that will lose effectiveness. But there are a whole bunch of other things they can do, and for some, actually, perhaps a scarier prospect is that they can essentially issue stop orders. They can require you to stop processing the data in the way that you are doing, which could have far more of a repercussion for a business than simply an administrative penalty. I think the final piece I would say is that also the implementation of this, I've mentioned fines, I haven't mentioned criminal sanctions, and there will be some criminal sanctions that flow from this. That's driven by each member state. They can make up their own mind as to whether they want criminality to attach for this. The UK was one of the earlier ones to come out and say, yes, we will have some criminal sanctions. So, for example, from a UK perspective, if you're a processor and you keep on to data longer than you have the authority to do so by your controller, then that's a criminal sanction. That's a criminal breach. So that's something which cloud hosting and other service providers need to pay attention to.
Wow.
That's a lot to think about.
And, in the interest of time, I might just recommend we skip slide 13, but rest assured, I think people will find out, even if you yourselves do not notify, others will find out. This is the nature of today's world and the nature of data breaches.
Yeah.
Somebody always knows, and the worst case scenario is you should have informed a regulator and they found that through other means, as opposed to,
right.
You probably don't want to know this, but here you go anyway. The worst case is the other. We wanted to know this and you should have told us. So, look, if that is all this is, what can we do about it? Let's turn to that in the remaining time that we have, with charts for those playing at home at slide 15.
Okay. So, it's something which, having spelt out some of the scope of this thing, in essence, this is not an impossible task. Ultimately, businesses are working their way through it. It's a journey, but ultimately you have to start somewhere. And so what we're typically seeing is that planning starts really with just breaking it down into various work streams. We have our tracker tool, which you'll see a link to at the end of the slide, which helps you to sort of think through some of those work streams. But let me break it down a little bit. Some of those things will be, in essence, as Michael alluded to earlier, doing some mapping, doing actually some data auditing, understand what you as a business actually have. What data do you have? What do you do with it? Who do you share it with? Do you need all of it? And encapsulating that. That's both necessary because as part of the requirements you have to create what's referred to as a data record, which specifies your data categories, who it's about, who you share it with, etc. And that has to be available to be produced to the relevant authorities. But it's also necessary because you need that factual snapshot in order to then inform what you do in your privacy policies and notices, etc., flowing from there. So that's the key starting point. From there, you can then choose work streams which might be updating your privacy notices, so complying with the transparency requirement to update that, tell people what you're doing with the data, following the list of prescribed requirements about what that needs to include. So it is more expansive. It is what you have, who you share it with, how long you keep it for, what protections you put in place if you transfer it, etc., what your lawful basis for processing is, what their rights are and how to exercise them and how to contact you to do so. So more extensive than you're familiar with from a US perspective. Consent is exercising a lot of attention at the moment because of the interaction between both this law, the GDPR, and specific rules on marketing, which are found within what's referred to as the e-privacy directive. That too is undergoing some review at the moment, and unfortunately the timing is not aligned. So there is a bit of a disconnect when it comes to things such as direct marketing. So a lot of attention being paid to that to work out is the existing consent sufficient? In a lot of cases it won't be. Do you need consent to actually do the marketing, or can you rely on legitimate interest and an opt-out, which is more limited in scope? And then looking at how you do the repapering for that lawfully, bearing in mind that emailing somebody to ask for a consent to market is itself marketing. So you have to be quite cautious about how you approach that. Other actions we're seeing right now, a lot of activity on due diligence on processors and other service providers. So looking forward, making sure you get the right things in place to check that your service providers are keeping your data secure, only using them as you expected to, and then making sure you have the right wording in place with them, because if you are appointing a data processor, the GDPR prescribes requirements that you have to put in place in your contract with them. It's quite an extensive list. This is literally pages of clauses that you have to put in place with those third-party vendors. So it is something to be reviewed, and it's pretty unlikely that you have covered all of those things already. That's leading to a major repapering exercise that's kicking off right now, and a major variation exercise to manage, because it not only applies to your forward-facing new contracts, this will apply to all your existing contracts going forward. So it's the legacy effort that is engaging a lot of time and attention, because clearly that can quite literally be thousands of contracts that need to be varied over the coming months. As I mentioned, data retention is also top of mind and getting early attention because of the practical difficulties associated with that. Not only are the policies being looked at, dusted off, and refreshed so that accurate information about how long you need to retain information for example, having regard to tax or limitation periods from a claims perspective, but also then thinking about, okay, we have this data on our systems, we know we'd like to delete it, how exactly do we do that? What systems do we have? Can we in fact delete this data, or are we left with some legacy systems that actually it's pretty difficult to delete them? In which case, thinking about sort of mitigation steps you can take, whether that's anonymization or other steps to deal with that. Data transfers, still an issue, and a very live one at that. That's maybe a topic for an entirely different webcast. But in essence, you'll have to think carefully about whether you're relying on Privacy Shield or European Model Clause agreements or binding corporate rules in order to deal with your transfers of data outside of the EU. And then whole swathes of policy documentation to be created above and beyond what you might have in place already. Broader statements of what you'll do as an organization, so your general data protection policy, your stance on your adherence to the rules, how you'll deal with security breaches, making sure you do have a policy which you stress test, you do your gameplay towards that, you make sure you can comply, because as we mentioned earlier, there is a tighter rule here. You've got a 72-hour window from your awareness that there is a data security breach to work out, do you need to report that to the relevant regulators, and do you need to notify the individuals concerned? You need policies to underpin the exercise of individuals' rights, and just to highlight what those rights may be, I've mentioned access already, but they have a right of erasure. You might have referred to this as the right to be forgotten, but in essence this is a right of erasure. There's a right to object to processing, there's a right to transfer data to other organizations, so a whole range of rights, and you need to have both a policy and, perhaps more importantly, a process with which to deal with those. And then finally, training and awareness. You need to make sure people know about this stuff within your organization. These policies can't just sit on the shelf. They can't just sit on your intranet. They have to be lived to. And your training will be critical in that regard. Having done all of that, will you be putting your feet up? No, you'll be then saying, actually, now we need to go back, we need to audit, we need to check in relation to that. So that's just a taste of those work streams that you'll be doing. Perhaps maybe starting out all of this, you might be thinking, how do we start? The other piece of this is to think about your governance, because this is critical to your accountability here. You need to think about, as an organization, who is going to take responsibility, who, maybe from a senior perspective, is important. It's expected that the senior management will have an overview here. You may have to appoint a data protection officer in some circumstances. Not all processing means that you'll have to do so, but if you're doing certain types of processing on a large scale as part of your core business, that might be required. Even if it isn't, you will be expected to be able to demonstrate that actually this is our structure of governance in relation to privacy and compliance with the GDPR. And so you may as well embrace that at the outset as you start to pull your compliance program together.
Yeah, and we talked about this. Well, there will be some conflicts. Mm-hmm. There's also some convergence. And, there are already requirements to post privacy statements mm-hmm. For U.S. companies. And, there's a question that we can work through, whether just to amend those mm-hmm. to right. be GDPR compliant or to have separate ones. I think those are sometimes going to be individualized determinations, but also, from a cybersecurity perspective, doing some of the things you just mentioned, Paula, like, having these training plans, revising those training plans, response plans, having training, they're all
data mapping, right?
Yeah, they're all best practices as well. So it's not all bad news in the sense that you can kill a number of birds with one stone, but it is a heavy lift, and as you keep saying, it's a journey. And
it's a deadline of May 25th, 2018. So we do want to mention that there is this deadline coming up. Yep.
And obviously we've flagged a lot of issues, probably raised a number of questions. So up on the screen now is some of our key contacts. We're happy to answer additional questions to help you on your journey. But we also have a GDPR tracker, which you can download. We've got the web address there. And I see we're at the top of the hour, so just on time. And
we will be getting back to everyone who has raised questions with us. So we'll get back to you. We'll contact you on your questions.
Absolutely. But otherwise, thank you all, and thank you to MJ and to Paula.
Thank you.
And thank you, everyone out there. I hope you found it illuminating, entertaining, and, of course, not too scary. Thanks again.
Thanks.
Bye.
Bye.
Thank you. Bye-bye.
This concludes today's teleconference. You may disconnect your lines at this time and have a great day.